Welcome to our Professional Insights podcast. My name is Laurie Scherrer. I'm an active member of Dementia Action Alliance. Today, I have the privilege to interview Rebecca A. Hobbs. Rebecca is an associate attorney with the law firm of O'Donnell, Weiss, and Mattei, with offices in Pottstown and Phoenixville, Pennsylvania. She focuses her practice on elder law, special needs planning, estate planning, estate and trust administration, and veterans benefits. Rebecca is certified as an elder law attorney by the National Elder Law Foundation as authorized by the Pennsylvania Supreme Court. Rebecca received her Bachelor's of Art degree in English with a minor in political science from Eastern University. She received her Juris Doctorate from Regent University School of Law. She's licensed to practice in both Pennsylvania and in New Jersey. Rebecca is an accredited attorney for the preparation, preservation, and prosecution of claims for veterans benefits before the United States Department of Veterans Affairs. In 2018 and 2017, Rebecca was selected for inclusion by Pennsylvania Super Lawyers as a rising star in the field of elder law. She's an active member of the National Academy of Elder Law Attorneys and the Pennsylvania Association of Elder Law Attorneys, and serves on the Special Needs Law Section Steering Committee through NAELA. As a member of the Pennsylvania Bar Association, she serves on the PBA Charitable Organizations Committee and the PBA Legal Services to Persons with Disabilities Committee. Rebecca is also a member of the Montgomery County Bar Association and is a co-chair of the Elder Law Section. Wow, Rebecca, thank you for joining us today. You certainly have accomplished a lot, and it's such a privilege to be able to interview you.
Thank you. I'm glad to be here.
We've talked about how the purpose of this podcast is to help people living with dementia and their families, to introduce them to things that are important to them. Tell me about, if I was just diagnosed with dementia and my partner and I came in to see you, what's important? What do I need to do? Do I even need an attorney? What's important?
Yeah, so that's a really good question. So what I think the most important thing to do when you receive any kind of medical diagnosis, especially a diagnosis of dementia, is to meet with an attorney and first make sure that you have all of your basic estate planning documents in order. And a lot of people must say, well, why? Why do I need to worry about my will? And it's not necessarily the will that I'm concerned about and what you need to have reviewed. It's your power of attorney documents, which I call your life planning. So it's your documents like your financial power of attorney, your healthcare power of attorney, and they may be called something different in each state, but in Pennsylvania, we call it a financial durable power of attorney and a healthcare durable power of attorney. And those documents are so important to have, and that's kind of the first thing you need to make sure you have in place, because why those documents are important is it's appointing an agent that can step in and help you make decisions if you're not able to make those any longer for yourself. So those documents are, the starting point. We should look at those right away whenever there's any kind of diagnosis, especially a dementia diagnosis. And then really it's coming up with the plan. When you have that diagnosis, it can be scary. It can be hard to think about, what the next step is. And a lot of people may just not even want to think about it and just kind of go on with their life, live their life. But it's so important that when you have a diagnosis like that, that you meet with someone and you come up with a plan. Come up with a plan as to, how you want to live your life. How do you want the rest of your life to look? Do you want to age at home as long as possible? Do you want to have family nearby that can support you in this disease progress? Do you want to have support in a facility? And it's important to have a plan in place and communicate that plan with your family.
What about, you had mentioned a plan B. why do I need a plan B if I have a plan A?
Yeah, so that's a good question also. So a lot of clients I have found the number one goal is we want to stay at home. We don't ever want to have to be placed in a facility. And that's their ultimate goal is age at home, age at place. I never want to have to be placed in a facility. And it's important because with any kind of health diagnosis, you don't know what that's going to look like for you. I mean, each person, the disease may progress differently for each person, and so it's important to have, okay, this is my goal. I want to stay at home. I want to have the support of my family at home. I don't want to go into a facility, but it's also important to have this plan B. What I have found with a lot of my clients is sometimes they're coming to me at a point of crisis. Maybe their mother was diagnosed with dementia and it's progressed to the point where they're not able to provide the support that she needs any longer. And they're faced with this difficult decision of, mom always communicated she wanted to stay at home, and now we can't keep her at home, and we feel like we're violating, who she is by placing her in a facility. And it's important to communicate with your family, okay, this is my goal, but I have a plan B that if you can no longer care for me at home, or if, the disease progresses to a point where it's not safe for me to be at home, I'm okay with this alternate, placement, maybe an assisted living facility, or maybe moving in with a family member, opposed to living in your own home, or just have a second plan in place. So that way the family feels comforted knowing that they're still honoring your wishes. It may look a little bit different than what your primary goal was, but they're still honoring your wishes.
And what do I do about my finances? I mean, when I was diagnosed, you try and do so much research online and figure finances out, but you hear people talk about special needs trust, guardianship, turning all your assets over to a loved one.
Right.
What do I do?
Yeah. So it can get really confusing, and it can be really confusing, especially when you start typing things into Google, because the reason for that is each state has different rules. So what you may read is true in Pennsylvania may not be true in Florida or in California. So it's important to make sure that, in my opinion, you not only do your own research online, which I think is still important to do, because I think it's important to educate yourself. If anything, it will provide you with the questions that you should be asking an attorney when you meet with them. But it's so important to meet with an attorney who has experience in special needs planning and in Medicaid, and can educate you on the state-specific rules on public benefits. So, when I have someone like yourself come meet with me, the first thing we're going to do is take a look at your assets and see, where are you at? Do you have long-term care insurance? Do you have enough assets to be able to pay for your long-term care? And then we may evaluate, doing some sort of Medicaid asset protection plan if we have enough time. So there's a 5-year look back period with Medicaid where any type of planning for trust needs to be done 5 years in advance, depending on your age. So this is where the confusion can occur, because Medicaid for someone that is over the age of 65 looks very different than Medicaid for somebody who's under the age of 65. So it kind of depends on when and at what age you're going to be applying for benefits. And, if you're under the age of 65, we may be doing a special needs trust. If you're over the age of 65, then we're a little bit more limited in what kind of planning we can do, depending on where you're at in that time frame. If we're doing the planning 5 years in advance, then there's still a lot that we can do. But each state is different. And, first that building block of making sure you have the financial power of attorney in place, and then meeting with an attorney to look at your assets, see where you're at, and help you come up with a plan of how you can finance the cost of your care. Because we all know, when we look at the statistics across the United States of how expensive it is for long-term care, even individuals that have done a really good job of saving that money can just go very quickly when you're paying for long-term care. So it's important that even if you have done a great job of saving, that you still meet with an attorney to figure out, what that cost of care is going to look like for you. I know in Pennsylvania, skilled care in some of the facilities can be as much as $150,000 a year. So for someone that's younger, that's looking at care for a very long time, that can be a significant cost for somebody.
I know before I found you, I had contacted something like 25 attorneys. How do I know? How do I know what attorney is right for me? How do I know someone's going to give me the correct information? And you're a member of quite a few groups. Where do I start?
Yeah, so my recommendation for where to start to find an attorney that practices in the area of special needs planning and elder law, I think a good place to start is the National Academy of Elder Law Attorneys. So it's a national organization, and that's the organization NALA that we referenced when you were reading through my bio. That organization has a find an attorney feature, and you can put in your zip code, and it will let you know the elder law attorneys and special needs planning attorneys that are within your area. Now, that may not capture everyone because you do have to be a member of their organization in order to show up on their search, but it is a good place to start because a lot of those attorneys are also going to be certified elder law attorneys. And that certification is, I call the gold standard for an elder law attorney or a special needs planning attorney. It's a way for you to know that individual focuses on that area. So elder law and special needs planning is such a complex area of the law, and there's so many rules. The area of law is constantly changing, so it's important to make sure that you are meeting with somebody who that's their primary focus. You don't want to meet with someone that does a lot of different things and then just kind of does this on the side. So having an attorney that really focuses on elder law and has their thumb on the pulse of the elder law, the new federal laws and new state laws, it's so important. So that website's a good place to start. Your local bar association is a good place to start. And then every attorney who is licensed through the state bar, you can go right to the state bar's organization and look up to see whether that attorney is in good standing with the bar. That's something you want to make sure that you check on as well.
So I want to really start by going to the National Academy of Elder Law Attorneys, which to me, that's kind of hard because I'm not old, but yet even though I'm not old, that's where I should go.
Yeah, and that actually is a really common misconception. And unfortunately, the name has elder right in it, but the National Academy of Elder Law Attorneys, it includes special needs planning, and that's for the individuals that are under the age of 65. So even though the name of the organization doesn't have that in it, it also includes that, and that SELA designation as well. So again, if you're under the age of 65, like I said, it is a very different type of planning. And there are some elder law attorneys that don't do special needs planning. So that's something that you make sure to ask them also, do you practice special needs planning, not just elder law?
Explain it. What is the difference between a special needs trust or a guardianship? When you say special needs planning, what kind of things should I be looking for?
Mm-hmm. Yeah, so special needs planning could include a guardianship. So a guardianship in Pennsylvania, and each state, it might be called something a little bit different. Some states call it a conservator, but guardianship is a Pennsylvania term, and some other states use that term as well. But guardianship in Pennsylvania, at least, is where an individual hasn't necessarily done the proper planning. So let's say that you have a parent or yourself and you haven't done, or a spouse and you haven't done the proper planning, you didn't meet with an attorney and have a power of attorney document done, then your medical condition progresses to the point where you can no longer sign a legal document because you no longer possess what we call legal capacity. So you no longer have the legal capacity to sign a document, and you can't handle your finances for yourself. Then at that point, the only other option would be to petition the court for a guardianship. And a guardianship then is where we have in Pennsylvania a formal court hearing where the judge would adjudicate an individual incapacitated, meaning that they can no longer make decisions for themselves, and they appoint a guardian to be able to make the decisions for them. With a guardianship, then you have court oversight. So whenever there's an expenditure of principal, you have to petition the court. So there's this court oversight where a power of attorney allows you more options because you get to decide who you want to make those decisions for you. You get to decide, what kind of power you want to grant to your agent. Where the guardianship, it's the court that's deciding for you. But special needs planning includes guardianships. It includes power of attorney documents. But it also includes what a lot of people refer to as special needs trusts or supplemental needs trusts. And the idea of a special needs trust, there's two primary trusts. So this is where it can get really complicated and people's heads start spinning with all the information. But the first type of trust is called a first party trust. And if you think about it, it's a trust that's created by the individual that's going to benefit from the trust. And it's created with that individual's money. Where a third party trust is something that someone else would set up for you, someone other than a spouse. So it could be where you have a young child that was born with a disability and the parent is setting up a supplemental needs trust for that child. Or it could be where you have an adult child that has a disability and is on public benefits, and the parent wants to make sure that when they pass away, the inheritance they're leaving to that adult child isn't going to disqualify them from the Medicaid that they're on. But usually in the situation that we're discussing where you have, a dementia diagnosis and maybe right away you need to kind of apply for public benefits, then we may be looking at a first party special needs trust, which is a way that the individual can qualify for Medicaid, qualify for SSI, but still have assets they don't immediately spend down. Instead, they're put into a first party special needs trust.
If I move to another state, so we live in Pennsylvania now, if we decide to move to Florida would be nice. Are you saying my paperwork may be no good anymore?
Yeah, so that's a good question. A lot of people ask, I'm in Pennsylvania, I've created this estate plan here. What happens if I retire in a different state or I need to move to be closer to family? And I always say that the rule is that if you've created an estate plan in Pennsylvania, then when you move to a different state, your estate plan is still going to be good because it was valid in Pennsylvania at the time you signed it. That being said, if you're still able to meet with an attorney and have them review the plan in the new state that you move to, so for example Florida, it's still advisable to meet with an attorney in Florida and just make sure that it's going to be good because you executed it in Pennsylvania, but is there anything you should do to make that transition easier? So sometimes it's advisable to update those documents. Maybe a few years have gone by since you signed them anyway, and now that you're in Florida, the power of attorney you picked, that lived really close to you in Pennsylvania, you might want to reevaluate who your power of attorney is in Florida. So I think it's good to have those evaluated and looked at. And then it's also key to know that Medicaid, yes, it's partially funded with federal dollars, but then also funded with state dollars, and that can look so different. The Medicaid rules and the plans look so different state to state. So it's important to make sure that you receive that education in Florida as far as what Medicaid would be available to you, in the event of you needing extra services that you can't afford.
Well, Rebecca, thank you so much for joining our Dementia Action Alliance Professional Insights podcast. You certainly have an impressive background, And we're looking forward to sharing all your expertise with our viewers. And I want to thank all of our viewers. If you enjoyed Professional Insights podcast, please subscribe to our channel and share it with others. Thank you all for viewing, and Rebecca, thank you again.
Thank you for having me.
We're living beyond dementia, connecting our lives to help us survive so we